Without further ado, I will pass you on to Geraldine Fleming.
Thank you very much, Gemma, and morning to everybody. Delighted you could join us for this session on pitfalls of contracting. In addition to Gemma's introduction there, if anybody has any ideas for future sessions, whether similar to this, pitfalls of contracting, or any other particular areas, please either again do type it into the chat or do email myself or Gemma with any other topic ideas that you'd like to see. So, as is normal for these particular sessions, we're going to go through a little bit about the company I work for, which is Contractor, and a little bit about me before we get into the main topic areas. So, as Gemma's already said, the company I work for is Contractor, and we are part of the Driver Group. We provide support to engineering and construction industries across all different types of sectors, whether it's building, power, infrastructure, process, or utilities. We were established in 1978. We're stock market listed, and we've got over 500 staff working worldwide. In terms of the UK, you can see a nice map there showing our different offices. Normally, I work out of our Hooton office in Cheshire, but you can see there we've got offices across Scotland and throughout England as well. There are three main parts of our group. We have driver project services on the left-hand side, and essentially we are a staff augmentation type business. So we can provide project managers, quantity surveyors and planners into live projects, and that is a significant part of the business. I work for Contractor and essentially providing contract advisory services, commercial and contract management, planning, programming and scheduling, as well as dispute resolution services as well. Finally, we have our Dialis business, which is essentially an expert witness division. So we can provide experts in quantum, delay and technical, and as an example, we've got several of our technical experts are working on I'm going to say cladding related issues, and as well as that we do also have adjudicators, arbitrators and mediators that work within Dialis. If you are a glutton for punishment and this particular session does inspire you to actually do some further reading, I can highly recommend our Driver Tret Digest magazine, which is produced twice a year. You can have that emailed to you directly if you get in touch with our marketing department, or alternatively, you can get copies from our website as well. A little bit about me. Sometimes when I'm giving these sessions live, I tend to get a few boos at this point, but hopefully not today because everyone's mics are of course off. So yes, I have a degree in quantity surveying. I'm chartered, and I used to work for a main contractor, which I did on and off for 5 years as a site QS. Working for Balfours, and I know there's a good few Balfour people who are on the session today, so welcome to you guys. After moving from Balfours, I moved into consultancy. I did a law degree over 4 years and completed my solicitor's exams over a further 2 years. And I've now been in construction claims consultancy for over 20 years. So that's a little bit of an introduction about the company I work for and also a little bit on myself as well. So I've chosen today a particular set of, I've described them as pitfalls of contracting, but certainly these are questions that I am asked regularly. So hopefully these will all be relevant to the types of questions that you guys have quite often. Whenever you see the word contractor in relation to the slides, you can actually replace that with the word subcontractor in the vast majority of instances. And of course, I appreciate that Seeker members are working either as contractors or subcontractors, or indeed both, so working in both areas. So question one, and I was actually asked this by 2 different companies last week. Can a contractor demand agreement on price before carrying out an instruction to varied work? Well, we always start with these types of questions with a very, very straightforward question back, which is, what does the contract say? And of course, we are governed by the contracts that are in place between the parties. You would need to look through the instructions clause and, of course, through the payments clause to see what they actually say about variations. Of course, the power to vary a contract is limited by the contract provisions. And I am going to say that I would expect that the Seeker members who are on today and your contracts or subcontracts that you've got in place, there will be a very, very wide clause that allows the employer in relation to the contractor and the contractor in relation to the subcontractor essentially to vary the work as they see fit. Also, there's plenty of contracts, and again, the vast majority of the contracts that you guys would be involved with will include contract provisions for submitting quotations for extra work. Now, they fall for me into two categories. They could be a quotation where the employer, the contractor, hasn't quite decided whether or not the work would be done. Or alternatively, it could be a situation where the employer or contractor definitely does want this work done, and really they're just trying, if possible, to get agreement on price in advance. So again, you need to look at those particular provisions within the contract. Of course, as well as having provision for providing quotations in advance, there are situations where there's no reference in the contract for providing those particular quotations. Looking at a few standard forms, JCT contracts, quite a few of those actually include something called a Schedule 2 quotation. And that actually allows the parties to assess the value of a proposed instruction or a proposed variation and to actually agree the price. That is not a mandatory procedure. Essentially, it's an option for the employer or indeed for the contractor. It's important to remember with JCT and with NEC, though, that whenever you are pricing a variation or assessing a compensation event, you must include everything to do with that particular item. Not just the direct costs, but we're also talking about your preliminaries and, of course, the time implications as well. So some of the JCT suite allows Schedule 2 quotations. Equally, NEC3, NEC4, again, do allow this quotation process as well. But again, I will say they are options. Under both forms, whether it's the project manager, contract administrator, employer's agent, they can actually get that quotation, then ignore it, issue the instruction, and then value the works in accordance with the contract rules. So it's absolutely not the case that this subcontractor or indeed the contractor can effectively say, stick their bottom lip out, fold their arms and say, I'm not doing this work until we have reached agreement on price. If you want that to be the situation, then you must include an express clause in the contract that says that we are not promising that we will do any particular variations on this particular project, and we can refuse to do any variations until the price is agreed. That would need to be an express term in the contract. So if you have got a situation where you have provided a quotation and then the employer or contractor is saying, no, you've got to get on and do the work. Well, how is that work then going to be priced? You've got your quotation, which is effectively sitting on the sideline. Well, it's no different than any other variation or any other compensation event. The vast majority of contracts that I come across will have rules very, very similar to this. So, in other words, if the work is of a similar character and executed under similar conditions to work that's already agreed in the contract, the starting point is always to use the bill rates. If the work is of a similar character, and that should say executed under different conditions, you use the bill rates, but you tweak it to suit those different conditions. So it could be that you're moving away from hand dig to excavation using JCB, or indeed it could be the other way around. So you would need to tweak the rates to suit those different conditions. Finally, if the work is of a different character and executed under different conditions, then you're going to have to put together a fair and reasonable valuation. And of course, that is where differences of opinion can arise. So, in other words, you have to then look at the definition of what a fair valuation or a reasonable valuation actually means. Now, quite often, that isn't something that's actually defined in the contract. And we have to go out to case law for that. And the particular case I'm going to refer to today is fairly recent, 2000 case, Weldon Plant and the Commission for New Towns. Now, this is the judge actually speaking here. So this is a quote directly from the judgment that was handed down. And he said in this particular case, fair valuation will normally mean cost plus a percentage for profit, with a deduction for any proven inefficiency by the contractor. But if there is proof of a general market rate for comparable work, it may be taken into account or applied completely. So just looking at that first paragraph, even there's a little bit of fogginess. The starting point is going to be cost plus profit, less any proven inefficiencies, but also by reference to general market rates as well. He continued, in my judgment, a fair valuation must, in the absence of special circumstances, include an element on account of profit. And particularly in relation to this case, he went on and said, first, a contractor is in business to make profit on the cost of deploying its resources, and accordingly, an employer must pay profit in a valuation made under any rule, or cost would otherwise not be a fair valuation within the meaning. Now, of course, those two slides were very much focused on non-NEC contracts, because NEC contracts have their own particular way of assessing compensation events. And the starting point on that, of course, is finding out which option you're on. Now, I've referenced here NEC3, but actually NEC4, in terms of what's on this slide, it's very, very similar. Of course, the last session that I did for Seeker was specifically to do with NEC3 option B and the assessments under that form. But in general terms, what you start by looking at under NEC3, whether it's the main contract or indeed whether it's a subcontract, it's clause 63.1. which states the changes to the prices are assessed as the effect of the compensation event upon the actual defined cost of work already done, the forecast defined cost of the work not yet done, and of course the resulting fee on top. So what we're looking at here is almost, and in many instances, it will be valuing the work twice. You value the work that's already done on the basis of actual defined cost, so the hours that the guys were actually involved in. The work that hasn't been done is on a forecast basis, a forecast defined cost. The defined cost is actually you have to look at the schedule of cost components. And there are two different versions of the schedule of cost components. We've got the shorter version under NEC3, which is the version that you use for options A and B. And then for options C, D, and E, it's the longer schedule or the schedule of cost components. And that's essentially a rule book showing you how you should actually value this particular compensation event. So going back to the particular question, can a contractor or a subcontractor demand price agreement before they carry out work? Well, one thing I would say is if the work is outside the original contract scope, then potentially, yes, the contractor can demand agreement on price before carrying out the work. That is a very, very rare situation. And I can only think of one example where that particular case has gone through the courts. It involved a dredging contractor who was then asked to build a bird sanctuary. And the court decided that actually that was outside the original contract scope. I would imagine for the vast majority of works that the people on this seminar get involved with, the instructions that you're given will be within the contract scope. So if the varied work is within the scope of the original works, then the contractor must carry out those works. Whilst, of course, the contractor or the subcontractor can provide a price in advance of starting the work, this can either be agreed by the parties or can be ignored, and the certifying party, so it could be the employer down the line to the main contractor, or the main contractor down the line to the subcontractor, they can ignore the quotation and value the works in accordance with the valuation rules in the contract. And again, remember, you need to look at the particular form of contract that you're on. If you refused to carry out that work on the basis that, well, if you're not going to agree our price, we're not going to do this work, be careful. This would be a breach of contract, which would entitle the employer to claim damages. And that would be the additional cost of the second contractor carrying out those works that you have unreasonably refused to carry out. The only other item that I want to say in relation to this particular section is, of course, the parties could decide that they're going to add in a clause that demands that you have agreement on price. I would imagine, though, that that would be something that would be very rare to be agreed between the parties in a construction context. Okay, second question for today is all about oral or verbal instructions. Are they valid? Is a formal instruction necessary to confirm an oral instruction? And are you entitled to payment if that oral instruction hasn't been confirmed in writing, but the works have actually been carried out? Can I say, from my perspective, bearing in mind that we are on the information superhighway, where vast majority of us are walking around with smartphones in our pockets, generally we're pretty close to a laptop at any point. The thoughts of people now relying on oral instructions very much feels like yesterday's technology. And the advice I would give across the supply chain here is you shouldn't nowadays have clauses in the contracts relating to oral or verbal instructions. Everything needs to be written down. Now, the validity of an oral instruction will depend upon the contract that you're working on. And of course, those of you who are working on NEC3 or NEC4 contracts, I am sure that you're very familiar with clause 13, which confirms that instructions must be in a format which can be read, copied, and recorded. I did a couple of years ago have a person who put their hands up in one of the sessions I was delivering and very cleverly said, well, oral instructions and lip reading, surely? And I said, no. I said, there's yet to have a case that goes to court under NEC3 or NEC4, but I doubt very much that lip reading would come into this category. So definitely, and I do think the NEC have done a great job on this particular area, oral instructions are not allowed under the contract. When we look at JCT related contracts, it really is a mixed bag. The standard form of contract and indeed the design and build form both allow oral instructions, whereas the intermediate and the minor works don't. And so they replicate NEC3 and NEC4. And I have to say, it was very disappointing when JCT 16 came out that they didn't go down the route that the NEC contracts have. So you've received an oral instruction. You need to check the contracts to see if it's valid or not. If the contract does allow oral instructions, does the employer or indeed the main contractor have to then give you a follow-up written instruction to confirm it? Well, certainly under JCT 16, the standard form, no, they don't. It's not the employer's job or indeed the project manager, contract administrator or architect's job to do the following up. What needs to be done then? Actually, it falls to the contractor. And you can see the clause on the screen there. So it says, and it starts off positively, all instructions issued by the architect contract administrator shall be in writing. And it continues at point 2. If the architect or contract administrator purports to issue an instruction otherwise than in writing, it shall be of no immediate effect, but the contractor shall confirm it in writing to the architect or contract administrator within 7 days, and if not dissented from in writing to the contractor within the 7 days from receipt of the contractor's confirmation, it shall take effect as from the expiry of the latter day 7 days. So you can see clearly there that once you receive that oral instruction, it's the contractor's duty to follow it up. And actually, an oral instruction can take up to 14 days for it to actually take effect. Continuing with this particular clause, it says, if within 7 days the architect does confirm it in writing, the contractor then doesn't have to confirm it in writing, and of course it takes effect from the written instruction. If neither party confirms it in writing, but the contractor complies, then the architect can, I'm going to say, scoop it up at any time prior to the issue of the final certificate. And of course, then it would have retrospective effect. But those last 2 clauses are written very much in a may type. They can confirm it. It doesn't say shall. So in relation to JCT 16 standard building contract, and of course you could see that under NEC, under Z clauses, or equally you could see it in a main contractor's bespoke forms, payment for an oral instruction is only envisaged where the contractor confirms the instruction in writing or the architect contract administrator confirms the oral instruction at any time. Failure to confirm an oral instruction can lead to huge problems for the contractor. Firstly, the contractor could be in breach for not completing the varied work. They could be in breach for completing the varied work if it hasn't become an instruction under the contract. And of course, the 2 parties could fall out massively, because why would the employer want to pay when there isn't a clear audit trail in relation to this particular issue? A good story, or a bad story, depending on what side you're on, relates to a particular project I worked on probably now about 7 or 8 years ago. And it was work that was done on somebody's house. It was a big refit of a large house in North Wales. And the particular contractor involved, they were responsible for the full refit. And as part of this refit, there were going to be some solar panels that were put on the roof. The workmen went ahead and they put the solar panels on the roof, but they didn't follow the manufacturer's instructions. The client in this particular case was an architect, and the architect came up with a different method of fixing to the existing roof tiles, and the workmen actually followed those instructions. A few months went by, solar panels were working absolutely fine until there was a storm, and the solar panels actually, because of their fixings, were ripped off the roof in part. So you can imagine that the next day, effectively what you had were a number of panels that had actually been blown off and a number of panels which had been broken but actually were still in place on the roof. And of course, the employer in this particular case, with the architect, said, well, obviously you haven't fixed these properly. The architect denied knowledge of any oral instruction to fix these solar panels in a particular different way. And of course, the contractor then essentially didn't have a leg to stand on and had to replace the solar panels and repair the roof. And from memory, it was about £15,000 or £20,000 to do that repair work. So every single time I am involved in this situation of oral instructions, I can definitely see trouble ahead. So from my perspective, I would want all contracts to be amended so that, quite simply, all instructions are in writing and verbal or oral instructions are not valid. If you then manage to achieve this, of course, when you're working on site, you've got to cascade that knowledge down to the people on the workplace, that they mustn't accept verbal or oral instructions. Everything must be put in writing before any varied work is carried out. Okay, our third issue for today is to do with day worksheets. And the question that we're looking at here is whether hours can be amended on day worksheets after those sheets have been signed and returned. Well, certainly from my perspective, work being done on a day work basis is fraught with difficulties. Not only is there going to be a feeling from the employer that the contractor has put plenty of hours down on the sheet, the issue that I also come across is actually the sheets themselves aren't particularly completed well in terms of the nature of the work and why it is a day work and why that's the only basis on which the work can be valued. Having said that, putting in place labour allocation sheets where the work that's carried out is actually properly recorded is a good thing. I've put within the notes a typical provision in relation to day works, and again, this is from a JCT contract. You'll be pleased to note I'm not going to read the whole of this particular slide out. I'm just going to point out the very bottom paragraph that says, if you are going to value works on a day work basis, this particular contract says that vouchers specifying the time daily spent upon the works, the workmen's names, plants and materials employed shall be delivered for verification to the architect or contract administrator or their authorised representative not later than the end of the week following that in which the work has been executed. Now, I often see that clause amended, so it says that day worksheets have to be provided daily or within 24 hours. So to actually cut down the time period. Certainly, any of the contracts that I've seen, whether it's JCT or indeed amended NEC or, of course, ICE or ICC contracts, there isn't any mention in the contract of amending such sheets. And I have to admit that one of my favourite cases in relation to the issue of day works is the case of JDM Accord and DEFRA. And DEFRA stands for the Secretary of State for the Environment, Food and Rural Affairs. The summary of this case is essentially that if an employer fails to verify and confirm or reject day worksheets which are submitted in accordance with the contract, the burden of proof is on the employer to prove that those timesheets are inaccurate. Now, the story behind this particular case, I think, is interesting, and it all revolves around foot and mouth disease in, I think it was 99, 2000, 2001. DEFRA realised that they had a massive issue on their hands. Essentially, they would need to actually get rid of an awful lot of dead cows on a number of farms throughout the UK. So they set up what was essentially a day work contract. And I would imagine that an awful lot of the labour only type jobs are done on a similar basis, even 20 odd years on. So they had a situation where the contract between the parties was very simple. They had rates for the guys, they had rates for the machines, and they also had rates for particular materials that would need to be used. Those rates were essentially bare rates. There were no quantities against them because DEFRA, at the time the contract was placed, didn't know the extent of foot and mouth and how it would affect the farms in the UK. JDM were one of the successful contractors. From memory, there were 5 major contractors and 14 smaller contractors working throughout the UK. The account in relation to JDM Accord reached £37 million. And throughout the contract, they had been paid on account, but obviously DEFRA got rather twitchy about the level of the money that they were going to have to pay out. It got to an impasse between the parties, and DEFRA said, look, we do not believe the hours that your guys have written on the sheets. We've looked at them and we assess that actually this work should only be paid £32 million, not 37. JDM understandably said, well, hang on a second. We've provided the guys, we've written the sheets out on a regular basis, we've sent them in to you. You can't come back to us right at the death and say you're knocking £5 million off the account. And JDM reminded DEFRA actually as to how the contract was set up. The fact was that in the contract here, DEFRA were going to provide a representative on each site, and JDM then were going to countersign the sheets that DEFRA themselves had written out. But because of the extent of foot and mouth, DEFRA couldn't provide a representative on each site, so JDM themselves wrote the sheets out. This went to court, and the court held, as I said a few minutes ago, the evidential burden was on DEFRA to prove that the sheets were inaccurate. Because they couldn't prove it, DEFRA not only had to pay the outstanding £5 million, but they also had to pay interest on top. The Bank of England rate of interest at that point was 6%, not our current 0.1%. It was 6% as a base rate. The Late Payment of Commercial Debts Interest Act kicked in as well. Of course, that's 8%. So DEFRA had to pay 14% interest on top of the £5 million that they were held liable for. So in relation to this particular issue, the answer to the question, can the hours be amended after the sheets have been signed and returned, is a resounding no, because even in the case where there was silence from DEFRA on the inaccuracy of the sheets, the court said, DEFRA, it's your responsibility to prove that those sheets are wrong. And of course, the takeaways from this in relation to contractors is definitely to provide those sheets on time. Make sure that you've got an audit trail, because I've come across organisations who have lost the sheets that they were hand delivered on site. So make sure that they go through, whether it's email or via a covering letter. Make sure that you follow those up. Make sure you price them and include them in valuations going forward, and essentially keep the pressure on in relation to payment for those items. Our next item that we're going to talk about today is all to do with completion. And of course, again, all different contracts that you guys come across, you will see different terminology. NEC contracts use the phrase completion. JCT contracts use the phrase practical completion. ICE and ICC contracts use the phrase substantial completion. And essentially what we're looking at here is, what do those terms mean? And also being aware as to how those terms can be amended. So looking at the phrase practical completion, and I'd probably say substantial completion is very, very similar. Actually, most forms of contract don't define practical completion or substantial completion, but it's generally held to mean that the contract administrator, architect, engineer considers that the contracted works are finished and any items of outstanding work are insignificant and they don't affect the proper use of the building or the particular engineering facility. In other words, that they are de minimis or tiny. It's important that everybody recognise the importance of actually having a physical date, because that can mark a number of important milestones within the contract. It could be the end of the performance bond, the end of the contractor's liability to insure the building or the engineering structure. Of course, liability for liquidated damages or delayed damages ends. It's the start of the rectification or defects period. If retention does apply, then of course, half retention release is normally due. The right to regular interim payments might also end. it would be the end of the entitlement to any extension of time and loss and expense. The period for the final review of an extension of time does start, and importantly as well, it's the start generally of the limitation period. A particular case I've got on at the moment does indeed relate to cladding in this particular issue. My subcontractor client in this particular case received a first letter from a solicitor probably about 2 months ago now. So that would have been around the middle of January 2021, alleging that there were potentially defects in the cladding works that they'd done on a job. And of course, that particular subcontractor sent that letter across to me and said, what do we do next? They've asked us to sign something called a standstill agreement. Should we sign it or not? We don't even know what the defects are that they're talking about. We don't know if we're liable. And I said, well, the starting point for me is actually, are you inside or outside the limitation period in relation to this particular issue? And I said, what I need to know from you is I need to see a copy of the contract, and I also need to know when you finished work on site. They dug out their records, and it just isn't clear as to what their last day on site was. It seems as if they were on site in October, November 2008. Now, of course, if you add the 12 years on to October 2008, that would bring us to October 2020. And so this letter that then came in January, effectively, they're outside that limitation period. But there are other factors, of course, that come into play as well. The account wasn't agreed for another couple of months, and collateral warranties took several months to be provided as well. So there's definitely a grayness and a fog about this limitation period. The contract also called for the subcontractor to write and confirm to the contractor when their works were finished. And unfortunately, in this particular case, my subcontractor client did not write a letter to say, dear main contractor, we confirm our works on site are finished, which would have actually drawn a line under this. So again, watch out for that in your contracts. NEC3, NEC4 contracts, of course, do talk about completion rather than practical completion or substantial completion. And it does include a definition, although again, I will say it is a bit of a woolly definition. So defined term 2 in NEC3, NEC4 says completion is when the contractor has done all the work which the works information states he is to do by the completion date, and corrected notified defects which would have prevented the employer from using the works and others from doing their work. If the work which the contractor is to do by the completion date is not stated in the works information, completion is when the contractor has done all work necessary for the employer to use the works and for others to do their work. It seems a very good definition until you actually look at the works information and see whether that works information actually ties up. If there's a clause in there that says all of the works stated in the works information must be done prior to the completion date, there needs to be a little bit of further knitting together in the works information for this to work properly. I've also put it in the notes, JCT 16 design and build subcontract. Again, I'm not going to read all of this out, but again, this does call for the subcontractor to give a notice. And again, it uses the phrase practically complete and complying sufficiently with various clauses in the contract to provide documents. The contractor then has got to reply within 14 days if the contractor doesn't agree. Otherwise, practical completion is deemed to be achieved. So again, in relation to some contracts, that notification is mandatory. Actually, I would say even under NEC contracts, I would say it's a good idea for the contractor or subcontractor to confirm when that work is actually finished. It is very common in both JCT and NEC contracts to see those clauses amended further. The first example I'm going to give you here is it particularly in this particular example, it ties completion up to the provision of operation and maintenance manuals, as-built drawings, calculations, and certificates. So that is extra provisions that are required. A second example I can give you here, this was an amendment to a JCT. It says practical completion means that the works are complete in all respects, save for minor items. And it goes on, you can see that the highlighted bit in the second part of this particular clause, that it means this or any other thing to be done. Okay, so in other words, that could also include the provision of any paperwork as well. Definitely, my advice on this is you need to check your contracts. What do they say about completion, practical completion, or substantial completion? I will definitely say you need to follow the procedure within the contract. If the contract is silent on giving a notice as to when you think your works are complete, I would advise that you should still give that notice because you want to keep clear documentary evidence of the date you believe your works are finished. It's a very important date, as we've seen, for liquidated damages or delay damages, extensions of time, bonds, collateral warranties, and also, of course, for liability in the future as well. The final issue that I want to talk about today is omission of work. And again, this is something that comes up regularly in relation to both main contracts and subcontracts. So the first question here is, if work is omitted by way of a variation, can the contractor or the subcontractor successfully claim for profit lost as a result of the variation? And would it make any difference if the work was omitted and given to another contractor? Well, the general position is that omission of work by variation actually isn't a breach of contract. Because if you look at the variations clauses or the compensation event clauses within your contracts, you can actually have variations or instructions which are an addition of work or indeed an omission of work. And normally the contract sets out how the omission of work has to be valued, whether that's by bill rates or fair and reasonable basis. In other words, quite often the position is that the contractor does have to credit the profit on work. But you also do have to remember that the contractor is not just obliged to carry out all works, but is also entitled to carry out those works. And it isn't a situation where that the contractor can be given a piece of work to do and then work can be taken off that contractor and given to others. And the general position is that it is a breach of contract if work is taken off one contractor that they were contractually entitled and obliged to do and it was given to others. And we've got two clear cases on this. The first one involved AMEC Building and Cadmus back in 1996. And this was a provisional sum for a food hall that was included in a contract. From memory, the provisional sum was about the £300,000 mark. Cadmus, the employer in this particular case, realised that the piece of work in relation to the fit out of the food hall would quite simply involve AMEC subcontracting that out to another party. Cadmus realised that AMEC were going to add their 10% or so overheads and profit on top to that subcontract amount. So Cadmus decided to place the order direct. As you can imagine, AMEC weren't very happy about the fact that they'd lost the right to do this £300,000 worth of work and it had gone elsewhere. So they decided to sue the employer and said that the employer was in breach of contract and that they were both obliged and entitled to do that work. The court in this particular case agreed with AMEC and said that Cadmus were in breach, even though it was a provisional sum. AMEC was still obliged and entitled to do that work. So in this particular case, AMEC received compensation of around £30,000, and so Cadmus were essentially not any better or worse off, because of course they were always obliged to pay AMEC the overheads and profit on top. The second case is a 2003 case between Abbey Developments, who were essentially acting in a developer contractor category, and PP Brickwork. And what happened in this particular case is that the developer was not happy with the bricklayers' speed of progress on the project, and they decided to actually supplement PP's labour on the project, and they brought in more bricklayers. Of course, you could say that Abbey Developments did that from a sensible perspective. They didn't want the job delayed, and no doubt if the job had have been delayed, they wouldn't have been able to sell the properties on as quickly as they would otherwise have done. However, that giving work to another bricklayer was essentially the same situation as we saw in AMEC and Cadmus. Work was taken off PP Brickwork and was given to others. The court said that the contract between these parties was absolutely clear. In the event that PP Brickwork were not proceeding regularly and diligently, Abbey's ability was quite simple. What they could do is terminate the subcontractor. Alternatively, of course, they could have come up with a deal whereby part of the work was taken off them and they had almost a drop hands situation in relation to the finances. That wasn't what happened here. Abbey Developments took a unilateral decision to take work off PP Brickwork, and PP Brickwork, as a result, were entitled to their loss of profit. There has been a very recent case on this up in Scotland involving a dredging company called Van Ord and a Spanish contractor called Dragados. And this particular project took place in Aberdeen, and it was a harbour expansion project. The main contractor being Dragados, and the subcontractor was Van Ord. The works involved soft dredging, and it was an NEC option B. Now, you could say in this particular case that Dragados were rather naughty. They initially let the dredging works to Van Ord, but then realised that there were actually cheaper options on the market. So they also let other subcontracts for dredging to other organisations. And they did a little bit of cherry picking. So in other words, as and when they saw a particular package of dredging that was needed, if they could get somebody else cheaper to do the work, they omitted it from Van Ord's subcontract and they actually gave it to others. Now, you can see in this particular case that it feels very similar to the AMEC and Abbey case. Do you remember I talked about that Van Ord in this case should be obliged and entitled to do the work? In this particular case, the judge went back to the Abbey Developments and PP Brickwork case, and they did look at this issue of that the contractor had a right to complete the work. However, the court decided in this particular case that the motive, the last line, the last bullet point, the employer's motive or reason for instructing the omission of work is entirely irrelevant. The court agreed that it was a breach of contract, but they also said it was a valid instruction under the subcontract. They said this was not an unusual situation, that compensation events under NEC often arose from a breach, late access, late information, were similar breaches, and quite simply, you valued that in accordance with the contract. So the court, I'm going to say unusually here, decided that the dredging work that had been taken off Van Ord and given to another contractor by Dragados was simply a compensation event and should be assessed on the value on the normal basis, in other words, using defined cost. And the court decided that that wasn't an unfair way. Essentially, the parties had agreed how omission of work would be valued, and essentially Van Ord were not better or worse off. Now, this is definitely an unusual situation when you compare it to the Abbey and the AMEC case. However, at the moment, this is what you would class as good law in relation to NEC contracts, and therefore going forward, I think we need to be a bit careful in relation to this issue of omissions of work. Okay, we have just about made our deadline, 10:54 on my clock. I am keeping my fingers crossed that we will finish on time. Gemma, have we seen any questions that have come in here? I'm biting my nails at this point about any questions. Gemma obviously realizes it's an unusual instance for me to finish slightly early. Hi, how are you doing, Gemma? I can't see. No questions?
I just had a phone call randomly right at the end.
Oh,
Apologies
typical.
for that. Right, I'll just have a look on here. Typical. Everyone's ignored me for the last hour. Right, we actually don't have any questions that have come in.
Excellent.
So you
Perfect.
got away with it today. We have one comment that's come in from Guy. Just obviously thanking Geraldine again for a fantastic webinar. We've actually just had one. I've spoken too soon, Geraldine.
Oh, that's fine. If you want to pop it on the screen, that would be great.
I will just bring this up for you. So.
Excellent, brilliant. Okay, so I'll just read this out here. So Daniel is saying, if 50% of the work was omitted by the client, would that not constitute an entitlement to a loss of profit? Daniel, up until this Van Ord case came out, I would absolutely agree with you that my advice to clients would be that if you have a clear contract in place and works were then omitted, I'm going to say, and then given to somebody else, that for me would entitle the contractor to a loss of profit. Okay. Because of the Van Ord case, I think we need to be a little bit careful, particularly about NEC contracts, and I am waiting to see if there's further case law in this particular area. The other thing I'd say about your question is that it's couched very much in just having an omission of work on its own. And you don't mention there work being passed on to somebody else. Now, again, it's going to depend on the particular contract terms that you have in place. Bearing in mind that you've signed a contract that allows addition of work, but also allows omission if the work isn't passed on to somebody else, then I think there's actually a very good case there to say that there wouldn't be entitlement to a loss of profit. What I would say is that both parties would need to be very careful as to how that omission is actually valued. So if I go for a very simple example, it's £100 worth of work that's carried out over 10 weeks. You've actually now only got £50 worth of work that's still going to be carried out over the 10 weeks. It's likely that you're going to have a similar level of site overheads, and that obviously needs to be factored in. And I would say that the cost of the overheads would be of a bigger concern than the loss of profit. So omission on its own generally wouldn't entitle you to a loss of profit, but it would potentially still entitle you to a loss of overheads, but you'd need to look at the facts of the particular case. Okay, do I think there might be another one? Okay, well, what is the time period for the contractor being able to pass on omitted work? To a great question. So let me come up with a couple of scenarios. Scenario one, the contractor's entitled to do the work's taken off the contract, and it's instantly given to a second contractor. That's pretty much what happened in the Abbey case and also in the AMEC case. So we've got clear issues there. If it's an immediate issue, where work is given to someone else, that obviously is a clear indication that there would be an entitlement to profit. I'm just parking the NEC exception to one side for a moment there. I think it's going to come down to intention. And if there is an audit trail that essentially shows that the reason for work being omitted is quite simply so that the work can be done more cheaply after the first contractor is finished, I think then there would still be an entitlement to loss of profit. If, however, it's done for budget purposes, I'll give you an example of a housing authority scheme. They only have limited funds for developing a particular site, and they decide to leave 2 houses not completed on the project. And then 6 months later, they get further funding from Homes England. Then I think actually in that particular case, there is a clear audit trail to say that there was no intention to omit work and give it to somebody else. They had no choice but to omit work because of this funding issue. So again, each on its own facts. The difficulty for the first contractor is going to be in proving the intention of the employer at the time that work's omitted. Okay, I think we've got another one, Gemma.
The last one.
Right, okay.
For me, but I'm definitely going to pass it to you, Geraldine.
Oh, thank you. Yeah, this is for you, Gemma. Right, the definition of completion in JCT, where sectional completion was not agreed to, and the contractor is insisting on completion without services in the building. Okay, right. A few issues on this. When we're looking at completion in a JCT contract, and indeed you can also have this situation with NEC, possibility number one is that there's just one end date. Possibility number two is you've got an overall end date, but you've also got contractually agreed sections. Possibility three is where you have an employer or contractor who actually wants to have partial possession. And I think, Samson, what you're getting at here is a situation where there's some kind of partial possession is actually happening here. If this is driven by the employer, essentially, it's going to be likely that they can insist on partial possession on a project. Okay. If it's a situation where it's the contractor who wants to force partial possession on an employer, that isn't going to work. It's got to be something that goes down the line. Samson, I think it probably is a good idea in relation to your question. By all means, do email me about your particular question afterwards. Okay, because it looks as if it's the contractor who's trying to force possession onto the employer, and my view would be that would be very, very difficult to actually force on the employer in that case. Okay, do we have another one, Gemma?
No, I think that's us.
Excellent,
done.
Brilliant, and we're just on the just after 11. Samson in particular, you can see my email address there. Please do get in touch with me, and hopefully everybody else, if you want to link with me on LinkedIn, I'd be delighted for you to do that. Gemma's going to give me the list of the people who want a copy of the slides, and we will send those in the next couple of days.
That's great. Thank you so much. Thank you to everyone for attending again today. Thank you to Geraldine. We've had some great questions, some good feedback again. So it's great to see so many numbers still coming along. So any feedback that anyone has on topics, things that they might want covering, or anything that Seeker could do to assist with regards to the training programs and seminar programs, please don't hesitate to drop us a line. You should all have my contact details, and obviously for anything contractual related, you should all have Geraldine's contact details as well. We look forward to seeing you at our next webinars. You should all receive direct invitations to those now. So thank you very much, everyone. We hope to see you soon, next month.
Brilliant. Thanks all.
Okay, thanks everyone. Bye.